Hey guys, Toby Mathis here, and today we're going to go over what is a living trust and how it protects your assets. Now, I've done a bunch of videos on living trusts, and I'm not interested in going and regurgitating that same information. What I want to do is put it in context to how a living trust actually operates in the real world, what it does, what it doesn't do, and why we use it for legacy planning, because it's really the only vehicle that we can use to protect your future generations. So let me just kind of break it down, and I'll go over bits and pieces so you really understand what it is and why people use it, and then why you might not want to use it, so you can make an educated decision. Number one is the way we hold assets as individuals. We have choices as to whether we want to take actions now that's going to impact the future. So, for example, I may hold a checking account in my individual name. And just that one little thing, hey, me holding an asset, a bunch of cash in my name may have an impact in the future when I pass away, if I'm incapacitated or whatnot, as to how those assets are treated and who gets to enjoy the benefit of that asset in the future. So if I hold it individually with nothing else, chances are I'm going to fall into a category of either intestate, going to probate using a will, or perhaps I have a living trust, in which case I'll still, if I own it in my name, when I pass away, it's going to have to be transferred. It's going to require the probate process. Unless when I set up those accounts, I do additional activity. So, for example, I could have a paid on death or a transfer on death statement with that account that transfers it to somebody else. And what I've done is I've kicked the can down the road, because now they hold it and now it's based off of their lifetime. This is true also for something called joint tenancy. A lot of times we hold our accounts with our spouses as joint tenants. And what that means is the survivor gets it. Okay, so let's say it's myself and my spouse, and I predecease my spouse, and now she gets the account. What happens when she passes, right? All we've done is kick the can down the road. Now it's her problem instead of just our problem. But that's still an option. A lot of people do this with real estate, for example. They'll have joint tenancy with right of survivorship. And what all it means is one spouse passes, the other spouse gets the entirety, 100% of it. Well, what if we have a mixed family or split family? What if I have other kids? Or what if that spouse gets remarried? That's how you get all those horror stories, right? When you hear about people unintentionally disinheriting their kids, that's the reason. It's because we're playing this kick the can and we're tying it to somebody else's life. The other example of that is if I have beneficiaries listed on, let's say, an IRA or a 401k, I may have retirement money, and I'm the beneficiary during my lifetime. But then when I pass away, I may have a beneficiary designation where it goes to somebody else, and now it's their asset, and they get to do with it what they want. When those assets, when they take them, there's no conditions. They could be a drug addict. They could be going through 20 divorces. They could have a creditor of $1 million hanging out there, and chances are that asset's going to get depleted. There's the lawyer brain of me is going over the cases where that's happened. And, again, you're kicking that can down the road. And then the other example I can give you is you say, hey, I don't want the hot potato, so I'm going to give it to somebody else. And you gift it to them during your lifetime, and now it's their issue again. All we've done under those scenarios is kick the can down the road. So if you want to handle and make sure that you have an estate plan, the legacy plan, or that you have these things buttoned up during your lifetime, you really have to go into the realm of using entities. There's not really another explanation. There are folks that'll say, oh, no, do the transfer of death. All you've done is transferred it from being your problem to somebody else's problem. You want to solve this thing, then I suggest you use entities. And let me just go over a few. Like there's LLCs, there's corporations, there's foundations, there's 501c3s, there's all sorts of entities out there, including trusts like living trusts that will live beyond you. So, for example, if I set up a corporation, you guys are all familiar with, let's say, Google or Microsoft or Meta. All these are big corporations. When I pass away, if I hold shares, does anything happen to Meta or Microsoft? No, of course not. It's because it is perpetual in existence. Those entities go on for life. So what you do is, instead of just holding an asset, for example, in my name, I'll hold it either in an LLC or some sort of corporate entity, some sort of structure. And by the way, if you have questions on this and you want to talk to somebody about your situation, all you have to do is go down into comments and write strategy. Just write the word strategy, and we'll send you a link so you can get a free consultation with somebody, so you can have somebody to bounce ideas off of. Well, at the end of the day, what we really care about is that people make intelligent decisions and informed decisions. And we have our biases because we happen to believe that a good estate plan's almost always, like I could almost say 100% of the time, is going to include a living trust. And it's because it covers you, your health, your finances, and upon passing, even during your lifetime, after your lifetime, you can actually create a legacy with it. Nothing else does that. So we tend to be biased, but we would still have the conversation about the entirety of your estate, because if you have real estate, stocks, etc., those might be held in a different vehicle. But that vehicle, let's say you have a stock account, for example, held inside of an LLC, so that you have some asset protection and also some continuity of it in the event something happens to you. You may have those LLC membership units held by a living trust, so that it's held in trust. So you're not just depleting the asset and distributing it out to people. You can actually hold it. And if you're smart about it and you create a legacy, which we'll go over here in a little bit, it might just benefit your future generations. And I said that with an S, not generation. You're not just giving it to somebody else and saying, now it's your problem. You're creating a situation where you could create perpetual wealth for your family. That's called creating a legacy. And there's a lot more you can do with it. So you have to use some sort of, like, before you're passed away, you got to have a transfer while you're still able to, right? While you're still competent, you have to do the transfer. So for example, something simple. Hey, I set up a living trust. I transfer my house into it. I transfer my checking account. Now, if something happens to me, I'm not running to court. I can avoid having to go to court. My heirs now would follow, or whoever I name as the trustee, which I'll go over in a second too. Whoever I name as the trustee to oversee that could be a third party. It could be a bank. It could be your heirs. They would follow the instructions that you've provided in that living trust. And the question a lot of people say, well, how do I know they're going to follow it? Well, there's laws that require it. And if you use a third party, a fiduciary that's a trust company, then there's really nasty things that happens to them if they don't follow it. So like you have recourse, as opposed to if you just name an heir. Let's say you have one child and you name them the trustee. They may not follow your directions, although there's probably going to be a bank or somebody saying, I want to see the document to make sure if they're distributing it all out that they have the right to do that. But it's smart when we dive deep on this to start looking at who could be sitting in these positions. So that's the entities. And I'll get back to the trust and I'll explain what they are, what these positions are, et cetera, so that it makes sense to you. But that just means, hey, it can't be tied to my lifetime because I'm going to pass away. And what I know for certain is that when I pass, I'm going to fall into one of three categories. Let me share my screen with you. Okay, you're going to fall into one of these three categories. I'm just going to make one is called intestate, which is no will, no trust. You go straight into probate. And what is probate? It's a court process to distribute assets. That's all you really have to know. I have to go to court. Are courts free? No. But lawyers make money in court. Clients, you generally spend money going to court. The last thing you want to do is go to court unnecessarily. And probate is a process that has been there's people all over the place on this. I've had ARP come up with estimates on a medium-sized estate that it's 20% of the estate get eaten up in the probate fees. You have statutes like California starts off at 8%. You have states like Pennsylvania where they have some, here's what appropriate fees are for lawyers and stuff like that. And it could be a pretty high percentage. But it's a court process, which means it's going to take time. And on average, it's about 18 months. Now, a bunch of lawyers are going to go into my comments and say, not in my state. Yeah, it depends on the size of the estate. If you have a small estate, you could do something via affidavit. More than likely, you have an expedited service for probate. But I'm talking about in general as an average. So there's below and there's more. Like there's probates that last years, 4, 5, 6 years, and then there's probates that last 6 months. End of the day, we don't want to go to court unnecessarily. Can we all agree on that? So all my friends out there that are lawyers that are going to jump up and down and say, but a will's just easy. Is it better to not go to court? Can we just agree that it's better not to go to court? Because that's going to lead us to one choice. Number two is you do a will. You see these, I got them in my state, $99 will. What are they doing? They're creating future clients by drafting a will, knowing that the heirs are going to come back to that law firm because it's all over the document, and they're going to probate it. Lawyers make a lot of money in probates. It's a multi-billion-dollar industry. Everything that's tied into those probates, it's a lot of money. So there's a reason that they do it. Not necessarily underhanded or mean or anything like that. A lot of times that's just what we're taught. Hey, it's better to go to court. Let's go in front of the judge. And there was a day when that may have made sense, but that day is past, right? Public records are easy to search, so people can see what's in that probate. They can target that estate. They do it with theft rings and with various, people making claims against the estate, or you end up with heirs popping up from all over the place, making claims against the estate, and you end up with conflict. And when there's conflict, there's expense and pain and grief and suffering. And so we want to avoid that conflict. And personally, the best way to avoid conflict is lack of disclosures, to keep your affairs anonymous and to keep things private, which means you keep them out of a public record, which means you don't go to court. But a will requires probate. It requires probate. I don't know another way to say it. What does a will require, Toby? Probate, right? You have to go and you're taking a written direction, giving it to the judge saying, this is what the decedent, this is what the person who passed away. So Toby's dead. Here's what he left in writing for who should get his estate. You're taking it to a judge. They're saying, here, we have to hold the estate open for a period of time so people can make claims. Are there any creditors out there? Are there any possible beneficiaries? Who wants to make a claim against this estate? Right? So they're going to open that up, and that's what probate is. And again, this is where all the nightmares, if you want to, just for kicks and giggles, talk to at the next cocktail party, you say, does anybody have any good probate stories? Anybody had a good fight that they want to share? I mean, there's so many cases out there. I highlight one. There was one in Georgia. It was over a plastic Tweety bird. It was a couple bucks, a toy, and a brother and a sister went to trial over it. And they're just burning cash. We had one here with one of our attorneys that Christmas plates, and just one motion fighting over Christmas plates was over $5,000 for one side, right? So the brothers and sisters are spending 15, 20, 30 grand fighting over plates. Okay, let's try to avoid that, right? And we can do that through number three. And number three is a living trust. And a living trust is a revocable trust during your lifetime. It's oftentimes called an inter vivos trust. All it is, it's a grantor trust, which means you ignore it for tax purposes. It's revocable, meaning you can change it whenever you want. So if you set this up and you're saying, hey, I want everything to go to my kids, as long as they're 40 years old and they've graduated from college, like you could put conditions like that in there, and they're not on drugs and alcohol, etc. Like you could put a bunch of conditions in there. Everything's private. You put those things inside that living trust, and then you decide, hey, you know what? I'm not happy. Maybe one of the kids has become independently wealthy or something like that, and you say, you know what? I really just want it to be for the benefit of my future generations. So you can just make it beneficiaries' descendants, right? So you could change that, even though when you first drafted it, it was, hey, it's going to my kids. You could change that and say it's going to go to my descendants, the blood of my blood, or afterborn, or adopted children, right? You can define it. You could be as narrow or as wide as you want to be, but it could go to your future generations. Now, here's the thing about a living trust. There's three parties to it. And the party that manages everything is called a trustee. The party that creates it and funds it you're a grantor, and then the trustee is holding it for the beneficiaries. During your lifetime, you're all three. If you become incapacitated, you could have a new trustee. When you pass away, this trust, which was revocable, it becomes irrevocable. When you pass away, you are no longer there. It now locks in at least your portion. So if you're married, it could be that your half gets locked in so that the beneficiaries can't be changed. And why do we do that? Because people get remarried, because people get estranged from their children. Like I could give you guys story after story. Here, I'll make one real for you. It was a situation where parents in a pretty fundamental church, dad was having an affair. Kids found out after mom had passed away, and dad basically said, screw you guys. I'm going to give it all to my new lover, and I'm going to cut you out. They didn't have an estate plan, so everything had gone to the dad. And the kids are obviously upset because dad was carrying on an affair for many, many years. They didn't realize. And just to add a little spin to it, is a same-sex relationship. So it was his best buddy, right? And everybody, I'm not making a judgment on it. I'm just saying that, could you imagine being the kids in that situation? And of course, the estate became something that they could yield as a weapon. And the question is, what would mom have wanted? Would mom have wanted for dad to be able to take the entire estate and give it to, his new relationship, his new partner? Or would she have wanted her kids to get the benefit of her estate? Clearly, mom would have wanted the kids, right? Regardless of the infidelity, she would have wanted her kids. But because of the way they set it up, hey, let's just have it go to the surviving spouse, the way they set everything up, there was none of that control. And I've seen this play itself out over and over and over again. Unintentional people that get, they, as they get older, they get married, even in the nursing home. We've had marriages in a nursing home, unbeknownst to children, disinherit the children because state law then controls, they don't even have a will, and it goes to the surviving spouse. You're like, oh my gosh, I don't think that's what they wanted, right? So what happens is when the first grantor passes, so let's say it's mom and dad, or, two spouses, one passes, it becomes irrevocable. Now we know who their beneficiaries are. And it might be that during the lifetime, it's the surviving grantor. That's usually how I draft them, right? So they go and the spouse is the beneficiary of the estate, but they're supposed to use their half of the estate first and secondarily use the decedent's estate. They're never going to want for money. They're going to have, it's going to be this, hey, if you have a sizable estate, obviously, then it's not going to be an issue there. What it is, hey, I want to make sure that my half, it goes to the benefit of my spouse. But when they pass away, when my wife passes away, here's who gets the asset. And it's these beneficiaries that I've named under the conditions that I've set out. And one of the beautiful things about a living trust, because these beneficiaries and having a trustee that's not just you, like this could be a bank, this could be a third party, this could be a relative, this could be this could be your decedents, but bank, third party, whatever, even a lawyer, accountant, a friend could be the trustee. But what you're doing is you're giving them instructions saying, here's how I want you to hold that estate. You can quite literally, let's say that we had a stock account in an LLC. So I'll just call it stocks. Let's say that we had a real estate holding entity. If you're around Anderson, you know that we advocate using this. And then you have a bunch of rental properties. So 1, 2, 3, 4, 5. Let's say that you have all these rental properties and that you had these held in trust. That means that the trustee doesn't have to sell anything. They could just manage these entities for the benefit of whom? You got it, the beneficiaries. They could just keep running what you create on perpetual for hundreds of years for the benefit of future generations. Now, how does that living trust actually protect us from these future generations? Because what if they get sued? What if they have a broken picker and get married 6 times, right? They just can't seem to pick the right spouse. What if they're on drugs? What if they're alcoholics? What if they, fill in the blank and they have legal problems? The trustee has the control over whether to distribute those funds. And there are spendthrift provisions, at least in our documents, that say if it's going to go to a third party, don't distribute it. If it's going to go to a creditor, then don't distribute it. So your estate doesn't get depleted because a beneficiary made a bad decision. It also doesn't get wrapped into the divorce or the lawsuit or whatever's going on, or a creditor can't get to it because it's not their asset. They're a beneficiary of a trust. That's it. And the trustee is ultimately in control. If a trustee gets sued, it doesn't mean anything to the trust because it's not their asset. They're just overseeing the asset. Who's the beneficiary? Who's the owner of the asset? It's that living trust. The living trust just keeps going on, and that's why we call it a legacy trust. When you see those created, they can go on for hundreds of years for the benefit of your beneficiaries. It could be organizations you care about. It could be like you could put in there provisions that reflect what you think is important. And the example I use over and over again is one that's important to me, which is traveling and making sure people get out there and travel around internationally so they see how the rest of the world is, so they appreciate what they have back at home. And all I can put in my document very simply, the trust will pay for you to leave the United States and go to a different country every year for 2 weeks. Yeah. Maybe that's as simple as that. Hey, part of what a beneficiary gets, if they want to be a beneficiary, they're going to have to travel a little bit and see the world. Okay, I could put that in there. My values are reflected in that, right? I'm not just giving somebody money, but I'm saying, here's what this money could be used for. Maybe you're very, very keen on getting a college education. So you could put in there that you're a beneficiary so long as, you could be a beneficiary for health in maintenance and support, things that make sure that you'll never be homeless, or that if you have an illness that you're not going untreated because there's assets here for those. But if you want a distribution, for example, let's say that somebody's entitled to 10% of the estate when they're 40, so long as you have a 4-year degree, like you could put a condition on that. You could put a condition on being a beneficiary that they have to by a certain age, get their college education. And that way, if they choose not to, at least you're not continuing to dump money on them if you felt that strongly about it. Or you just say, hey, that I really want my beneficiaries to get through school. And if you get through and get a 4-year degree from an accredited university, then there's a bonus. Maybe it's $25,000 index for inflation or something, so that there's an incentive for somebody to complete that. And yes, you're helping them go through school, but then you're also giving them a reward if they do it. So like you have those choices. It's up to you, and you're the one with the control. We can't do that with either of these two. Intestate or a will, we have nothing, right? When we look at these guys, all we know is that we have probate that we have to deal with. Now, if you have a living trust, you may possibly still end up in a probate situation on some assets if you don't transfer them into the trust. We see this all the time. People set up a living trust and they don't fund it properly. We always include with a living trust something called a pour-over will, which names the trust as the sole beneficiary, so that in the event that there's an asset, maybe it's a car, or maybe it's a checking account or something, you're able to go down and quickly transfer that asset, or open up hopefully it's a low asset probate because the vast majority are already held in the living trust. But you're able to just, with one beneficiary, you don't have a question about, people fighting over it, because the only beneficiary of your estate is now your living trust. That's how these things work. And I just want to make sure that you get a good understanding of what the world looks like when it comes to estate planning. So what did we go over? Kicking the can down the road, tying things to my lifetime. And then instead of just transferring it via a legacy plan, just giving it to somebody else and letting them deal with it on their lifetime, right? Never a good idea. Or if I gift something to somebody during my lifetime, all I've done is just transferred it to them. Here, Now you have to deal with it, and obviously you have no control over it anymore. And you could hurt people actually with gifts. There's some tax consequences as well. Like you lose your step up in basis, and they inherit your basis, and then also their creditors could take it. We've seen everything when it comes to that stuff with gifts. So the other route is, let's do something that does not die with me. Use entities to create a perpetual plan. That involves using usually LLCs, corporations, possibly foundations. If you're charitable, you could create a charitable foundation, just like Warren Buffett just talked about dumping billions of dollars into his kids' foundations. Those things don't die. They're perpetual, plus they're tax exempt, which is great, right? But we're using some sort of entity, and you're actually putting together a strategy. And one of those entities is going to be a living trust, which avoids probate and allows me to actually have control over my estate even after I've passed away. Make sure that I don't disinherit my kids, especially if I have a split family, or if you have children, you just want to make sure that a future marriage doesn't disinherit them. You can make sure that that's covered inside of a living trust. Living trusts are an excellent tool for asset protection of future generations. It's not going to help you at all, right? Living trust is revocable. It's a grantor trust, meaning it doesn't do a tax return. It's yours. When you pass away, that changes. Now it's an irrevocable trust. It has asset protection, and it's going to start filing its own taxes. But what really makes it great is that you can create a legacy. Because of those things, you can create a legacy that lasts hundreds of years with a very simple document. If you want to learn more about that simple document, just type in strategy into the comments, and we'll send you a link so you can talk to somebody about whether it's appropriate for you to set one up. I tend to be very biased about it. I think everybody should have one, but you get to make your own decisions on that one for sure. Make an educated decision by talking to somebody who knows what they're doing. If you like this information, like and subscribe. And if you know anybody that would benefit from it, please share this. Thank you.